May I please, your lordship, my prayers for listing a IA lordship, similar prayer lordship, modification of the order dated lordship, 4th of December lordship.
Alright.
Tomorrow lordship.
Yeah, please, Lordship. I beg to mention item number 43, my lord. I have filed an additional affidavit in my bail application, my lord. So, my lord, may I pray on listing the matter on 7th of January, my lord?
Submitted that an additional affidavit is being filed. Accordingly, the matter may be said again on
7th January.
7th January. Item 43.
43, my lord. Hello.
2 and 3, my lord. Maybe after some time, Mr. B.K. Mahajan is coming, man.
Earlier in this case, my lord, by order dated 18/12/25, my lord, scan copy of the CD plus TCR was called for, my lord. Probably wrongly listed for motion, my lord, may have to come up for bail hearing along with TCR, my lord.
My lord, let Mr. Mahajan come, my lord. It was earlier rejected, my lord. Co-accused has been granted bail, my lord. Charge sheet has been submitted, my lord.
Yes, sir.
That Narim case, my lord.
My lord, we will place the charge sheet before lordship. Thereafter, lordship may decide, my lord. Kindly, my lord.
After some time, my lord.
After some time again.
This scan copy is available.
My lord, scan copy, my lord, matter actually, my lord, listed scan copy not yet available, my lord, not shown in the cause list. And matter needs to be come up with the column.
Okay, let Mr. Mahajan come then.
Oh.
Please.
Like, my lord.
34.
My lord, 4 and 5, my lord. Today, my lord, 60 days, my lord. Maximum punishment in all the offences I have, my lord, takes, my lord, it is 10 years, my lord. Accident to 10 years, my lord.
111/2 is, my lord, 90 days, my lord.
No, 111 to Kimandi.
2B, my lord.
No, 111 to B.
2B, my lord.
For 5 years, my lord, which may extend to life. Oh.
90 days.
No, which may extend to life, also.
Yes.
90 days.
90 days, which may extend to life, my lord. Here, my lord, earlier it was rejected, my lord. 60 days, my lord. Today only on the length of detention, my lord.
Where's the FIR?
FIR at page 9, my lord. And my lord, relevant portion, my lord, it starts from page 14. Bill Asid Khana case, my lord.
Which paragraph is the present?
My lord, here
Yes,
the petitioners were not named, my lord. They are not named, my lordship's order is at page
We are
40.
seeing all this paragraph 1, 2, 3, 4, 5, all this is all history. What is the present FIR pertains to which incident?
Against the petitioners, my lord, lordship's order is at page 40. Earlier rejection order, my lord. Lordship has recorded my submission at paragraph 4 in lordship's order.
So material is there in the FI, CD.
Organized, my lord, extortion racket, my lord, running, my lord, these all extortion activities in various places of the state of Assam, my lord. Thereafter, my lord, by way of demand, treat, my lord, collecting money from various businessmen, my lord.
But
Also-
my submission is that, my lord, the 60 days in custody, my lord, as on date, my lord. So on further custody may not be required, my lord. And my lord, there is no specific allegation, my lord. All are, my lord, general allegations, my lord. Knows that this person has done this, my lord. There is no specific allegation against anyone, my lord.
I will get the updated case diary, my lord.
So 60 days in custody, my lord.
90-day offense, my lord.
90 days offense, my lord, but 60 days, my lord. Further custody may not be
Statutory
required, my
period
lord.
for, my lord.
Then due
completion of
vacation is also
investigation
there,
is
my
90
lord,
days.
next week.
Can you get the CD before the vacation?
Or vacation, immediately after vacation.
My lord, it will be long, my lord.
Yes, I will. Friday, I will.
SME's organization, Uruka is there.
My lord.
On 9th, my lord, I will try to get it. Updated CD, my lord.
All right, we can wait till 9th.
Lordship. 3/4 same order, my lord.
Counsel for the petitioner.
Foreign.
Call for the CD, list the matter on 9.
Oblige, my lord.
May I please your lordship? Same sorts of allegation lordship that, but I am for 71 days behind the bar lordship. Lordship earlier rejected it, but later on it was filed and prior to vacation.
Where is the order?
Order lordship will find on 54 lordship. Allegation was there for kidnapping lordship by those person. But whereas in fact, lordship, it is a land broker law and due to some disputes on criminal civil suit is also pending regarding that plot of land. And on that particular day, he was asked, they were asked to get the money. So they went to meet him, lordship. After delivering the money of 10 lakhs of rupees, thereafter he lost this case law. The trap almost, if we go through the FIR contents, it seems that there is a trap case, lordship. They were called and they were handed over to police. And page 41 annexure 8 is the title suit filed by them and it is a pending before the senior division 1 civil judge regarding that plot of land. And one more complaint was given before the DCP, and while rejecting our prayer on the earlier occasion, that part was not considered regarding that DCP part. That one complaint that regarding the same incident that lordship will find on page 34 against the particular person and
This page,
page 34.
page 59 order, Biraj Vallabh Kolita, that was specific to him.
And one person was granted bail.
That is the order I am
No,
reading.
that is different aspect. That we have shown that he was at that point of time in Arunachal Pradesh.
No, now this case is on behalf of which person? Biswajit
Person,
Dole. Biswajit.
sorry, lordship, the 54 is the rejection order. I told 59. 54 is the rejection order. Yes, same 4 persons are behind your lordship. I'm extremely sorry. That page 54. That 59 is different lordship. That
I think we'll need the CD.
considering the length of the 71 days lordship, and moreover they are from this from Assam only lordship. No chance of absconding lordship.
And this is my lord, matter. This matter is quite serious, my lord. This is not only the way how initially kidnapped, thereafter confined, thereafter demanding.
No, lordship,
my lord.
no, if
Not only
lordship-
like other cases
No.
of extortion, my lord. This is quite serious.
No, you know, confinement was absolutely not there, lordship. If lordship go to the FIR, lordship.
Anyway, I will get.
No, confinement was absolutely not there, lordship. It is a trap case, lordship. The civil suit is pending there. While rejecting earlier, lordship, court directed them to obtain the instruction status regarding the complaint before the DCP. That was not furnished before the court, lordship, on that part. And moreover, confinement is not there, Lordship. And it is a civil suit is pending regarding that plot of land. This same person, Lordship, who are behind the bar. They have given a complaint before the DCP. And now, Lordship, 71 days and further custodial detention matter. Person was recovered from that point of time, say, at the lodging of the FR. He was rescued. Thereafter, Lordship, FR has been lodged.
And if, my lord, civil case is pending, then also, my lord, this is not the way of recovering money.
No, not. We are asked to come there, Lordship, to collect the money. We
Right.
did not went there, Lordship. That is why, Lordship, we have filed it, complaint before the DCP 2 or 3 days ahead, Lordship. The complaint was there, Lordship, specific complaint was there, and that person who is the informant, Lordship, several, 2-3 criminal case has been pending against that person, Lordship. That is not, he is not so honest person, Lordship. He was informant.
Get the updated.
2-3, Lordship, criminal case has been pending against him, Lordship. 71 days, Lordship. He was not confined for a single day, Lordship. He was recovered thereafter the FR has been lost, Lordship. He himself lost the FR, Lordship. Where is the regarding that confinement, Lordship?
Where is the FIR?
Considering all these aspects, your lordship earlier rejected the bill.
That on page 17, Lordship will find the original. I put it in a series. The type copy on page 12, Lordship.
We'll see. Well, it's a novel. We'll have to read it.
Well, Lordship,
We'll see.
if Lordship desire to call for the case there, then prior to Bihu vacation, Lordship. And if
All right,
not-
9.
Yes, item 1, 2, and 3.
When you were to begin with, my lord, I'm sorry, my lord, I was there in another. Here, my lord, what has happened, my lord? Juvenile delinquency, no two ways about it, my lord. Some NTS miss, but anyway, these are besides the point, my lord. The background is this, my lord, very unfortunate happening, and date has taken place after 20 or 21 days, my lord. And thereafter, my lord, 2 boys, sorry, my lord, they can boys, but at the same time accused, my lord. All are similarly situated, my lord. One got the privilege of pre-arrest bail, and now that has been made absolute, my lord. And another accused arrested exactly same footing, my lord. He was granted the privilege of bail. Of course, my lord, he had epilepsy, my lord. Definitely, my lord, only on the ground of epilepsy, my lord. Now, my lord, 71 days, and here what has happened, my lord? All arrests have been made on the basis of CCTV footage. Now in the charge sheet, we have obtained certified copies, my lord. Now they say, my lord, that in the charge sheet, that the CCTV footage, nobody could be identified. That I'll also read, my lord. So first arrest, whatever was stated in the forwarding report, that all arrests were made on the basis of visuals appearing on the CCTV footage, my lord. And I'll come to read the FIR first, then that forwarding report where it is stated that arrests have been carried out merely on the basis of their appearance on CCTV footage, my lord. FIR is, my lord, at page 15, my lord. With all respect, my lord. May I? With all respect, my lord, with the reference subject goes on and on, my lord. However, when the second paragraph I'm reading, my lord, when Joseph became unconscious, the attackers under the leadership of Tofik Jahid Sanoiko draped from the spot saying something in Assamese. even though Joseph was living on the ground unconscious, they kicked and punched and hit him on his head and by helmet. When they left the spot, keeping Joseph unconscious, we took him to the nearest hospital and doctor told us his condition was critical and the attending doctor immediately admitted him in the hospital for his treatment. Under the above circumstances, we like to request you to kindly, my lord, thereafter the case has been registered. These are the boys' name, my lord. Now, why arrest was carried out, my lord? With all respect, my lord, also may kindly have a look at page 17.
Item 2 report, sir.
Lordship, may kindly take up item 2, my lord. Item 2 to car. Item 2 from Priyam Jyoti Kashyap, my lord. It would the pages would pagination would be correct then, my lord. FIR is same, my lord. The forwarding report by which the accused person was arrested, my lord, page 17. Relevant part, my lord. Page 17, my lord. Paragraph 2, grounds of arrest. During investigation, the CCTV footage of the PO was seized and on analyzing the CCTV footage, the arrested accused person, all days, my lord, Priyam Jyoti Kashyap, the Priyam Deka is on bail, my lord, of course on hell ground, my lord, were clearly seen assaulting the victim. Thus, from CCTV footage, the accused persons have been identified and arrested. This is the, my lord, with all respect, my lord, reason of arrest and grounds of arrest also possibly, my lord. Regarding these accused
What about
persons,
paragraph 3?
my lord, yes, my lord. The arrested accused person have been arrested on the statement of eyewitnesses recorded under section 180 BNSS, all co-accused, my lord. School, my lord, college, my lord. The BNSS were present at the PO at the time of occurrence of the crime. Yes, maybe, my lord. They may be there. The primarily, my lord, that CCTV footage. And in a charge sheet, my lord, yes, my lord. If there are co-accused statements, my lord, why detain them local for juvenile delinquency? If they remain in jail, they'll get chance to mix up with hardened, furthermore damaged. And my lord, they will never run away, no flight risk, local resident. Unfortunate happening and the spur of the moment. Somebody said NTSM's thing, it is apparent on reading the FIR. That should not have happened. Nobody would condone it, my lord. Unfortunate happening, it should not have happened. And then now let me read the, my lord, with all respect, my lord, the charge sheet, my lord. That CCTV part is gone, my lord. And I'll read the 2 bail orders, my lord, with parity, my lord, if possible, my lord. Again, remaining like gunny bags in jail won't serve them in the prosecution's purpose. After being charge sheeted, their presence is only presence is recurred during trial, my lord. May I read second paragraph, leaving aside 5 lines from the top, my lord. May I read, my lord?
Yes.
After visually, sorry, man, this is the language. After visual inspection of the video footage, it is observed that a group of persons had gathered at during which a man is brutally beaten up by a group of boys until he lost his consciousness. Subsequently, another group of boys intervened and attempted to resist the attackers. Juvenile delinquents, my lord, all. I should not say that this is possibly also, my lord. Subsequently, another group of boys intervened and attempted to resist the attackers. However, due to the factors such as low resolution of the video footage, camera distance from the spot of incidents, motion blur, etc., the facial features of the persons involved could not clearly be evaluated even after enhancement. Hence, it is not possible to make any conclusive opinion regarding the identification of the suspects seen in the footage. Well, whatever be it, my lord, let them face the trial. Because now if they are detained, there will be only gunny bags remaining there, my lord. And my lord, any condition, even a single default during trial, without showing an appropriate cause would lead to cancellation of bail, my lord. And it is a part charge sheet, my lord. Kindly see, my lord. Next page, my lord. Next page, leaving aside 5 lines, exactly the next page, my lord. However, I shall remain prepared to submit the supplementary charge sheet as and when absconding accused persons, namely Samir Ali, Afraz, are apprehended. If they are not apprehended, the final or the subsequent charge sheet will not come, my lord, while we remain in jail, my lord. And my lord, the 2 bail orders are, my lord, we have annexed, my lord, One is at page 41, the other is at page 45, exactly similarly situated. They were present at the spot, at the time of occurrence, at the place of occurrence, and being participants therein, my lord. Page 41 is interim bail granted, my lord, and this is the absolute. Absolute, that has been made absolute, my lord. 41 is interim, my lord. May I just charity, my lord, with all respect and folded hands, my lord. Samim Ahmed, he has been granted the privilege of bail, my lord. The my lord, with all respect, no, 41 to 41, my lord. I'm reading 42, my lord, with all respect, my lord. My lord, he was granted. It is further provided that the petitioner shall cooperate with the investigation, 50,000, my lord, interim bail. And thereafter, that by that order, that has been made absolute. And the absolute bail has been given to one accused who was in custody, not pre-arrest bail, my lord. Of course, on the ground of sickness, my lord. It begins at page 43. My lord, operative part is at page 44. My para 4 I am reading, my lord. Same materials. Page 44, para 4. The learned additional public prosecutor for the state with reference to the case that he has
This is
submitted
item
that.
number,
My lord.
item number?
I'm sorry, my lord. 2, my lord. You to dear name.
Two ends at page 37.
My lord. Page 37. Page 44, my lord. By which absolute bail was granted, my lord.
This is item 2, this last page is page
Priyam
37.
Jyoti Deka, my lord. Priyam Jyoti Kashyap, my lord. Now we are moving for Priyam Jyoti Kashyap, my lord. There at page 44, one accused was granted the privilege of bail on the ground of sickness, my lord, epilepsy, but therein also materials were same, my lord. Page 44. Lordship may have. Lordship may have.
Yes, yes, we have seen this.
Ah.
Now you can't claim parity on the basis of this.
I'll never pray parity, my lord. Definitely, no, I'm not meaning that. Why I'm saying only this, my lord. These boys, they have committed an offense, my lord. If they have committed it, my lord, if witnesses prove it, my lord, they will go face the consequences. Now, my lord, being students, at par, my lord, they will be in jail, and till the other accused persons are arrested, trial will not proceed, my lord. With all respect, my lord, because 2 are yet to be arrested, and what the police has said, my lord, exactly, my lord, where that page I'm reading out, my lord, with all respect, my lord, in the charge sheet, however, I shall remain the investigating officer, prepared to submit the supplementary charge sheet as and when the absconding accused persons, namely Samir Ali and Afra, same footing, my lord, they are arrested, my lord. My lord, adequate conditions, my lord, and on any date fixed, if we desist from appearing without showing proper cause, if somebody is fatally sick, my lord, then he cannot appear. My lord, otherwise it would automatically lead to cancellation of our bail, my lord. 115 days in custody, my lord, young boys, my lord. 21, 22, just because the, my lord, teenage, my lord. Chinna in prayer, my lord. Even I think state, my lord, of course, they object, my lord, in this sort of circumstances, my lord, whether objection is necessary or not. These are the factual matters. They cannot develop the case further, my lord. If there are witnesses, witnesses cannot be outside witnesses, my lord, with all respect, my lord, all inside the campus. All inside the campus, my lord. And my lord, regarding CCTV footage, that part. Let us face the trial, my lord. And if we have committed it, definitely, my lord, we'll put to gallows, my lord. All local residents, no flight risk, my lord. Adequate amount of surety. Every day we will appear. If necessary, we will appear before the investigating officer. After being charge sheeted also, every week or once a fortnight, my lord.
Yes, PP.
Your Lordship, I would just like to point out, earlier, my lord, the item, in the case of item number 1, at that point of time also, my lord, on 18/12/25, search sheet submitted. On that day, my lord, your Lordship, by order dated 18/12, your Lordship was pleased to call for the, my lord, scan copy of the case.
Good.
TCR. And today, my lord, certified copy of the search sheet, my lord, is not with me. And regarding the, my lord, I'm while taking the second case regarding the contents of the FIR, maybe definitely, my lord, an unfortunate incident, but how my lord, their action was how premeditated, my lord, my lord, weapons they have used, my lord, at the time of commission of the offense. Your lordship, from the FIR, I'd just like to point out, my lord, how cruel they are, my lord. All our friends were, along with some youths, attacked Joseph Sarto and started beating him seriously with helmet, hockey sticks, iron rods, and stones, my lord. So, my lord, if, my lord, at that point of time, though their acts are not premeditated, then where from they got all these iron rods, my lord, hockey sticks, my lord, by taking everything, how brutally they assaulted, and ultimately, my lord, after 14 days, because of that assault, my lord, victim expired, my lord. And now, my lord, finally, regarding that CCTV footage at that point of time, yes, at that point of time, in the ground over specifically mentioned that those big accused persons were identified through by way of that CCTV footage, and that is a, my lord, separate kind of evidence. And now, my lord, in the search sheet, although, my lord, not with me, that some, my lord, blurriness about that CCTV footage that is mentioned is there. But what about the eyewitnesses present at that point of time? The informant who has lost the affair, my lord, he has specifically named some of the, my lord, witnesses, my lord. He is the eyewitness, my lord. He specifically named, my lord, some of the person in the FIR. And what are the other witnesses, my lord? In the eyewitnesses, my lord, only search, after getting search sheet, I can point out to your lordship, my lord.
On the earlier occasion, when the matter came up before this honorable court, my lord, bail was about to be granted. It was not granted only because of one reason, because we filed an application because lordship was away. The procedure is, the honorable judge who rejects it, my lord, it has to go to his bench, my lord. In that order, it was written there, my lord, honorable Chief Justice, my lord. If mandatory period is over, only then it would be taken up, my lord. Hence, at the last moment, my lord, that scan copy was sought for, my lord. And even if the scan copy comes, it cannot be more than what then we have at the moment, the certified copy of the charge sheet that I am placing before your lordships, my lord. It is already there before your lordships, my lord. The scan copy cannot develop anything, my lord. And regarding brutality, my lord, yes, my lord, if brutality is there, even then, my lord, after being charge sheeted, there is no law in India that they be detained, my lord. That to juvenile delinquents, my lord. They will get chance to mix up with hardened criminals. Absolutely, my lord, budding lives, it would be spoiled. And regarding flight risk, he has never said that we will run away from justice, my lord. Even a single non-appearance without showing proper cause should lead to cancellation of our bail. We also know, my lord, a boy from another state has expired, my lord. Definitely, we are all sorry, my lord. It was a spur of the moment, and possibly, my lord, in the charge sheet regarding seizure of hockey stick, all those things, my lord, whatever was pure exaggeration so far as we are concerned, they have never been seized, my lord. Apart from that, my lord, 115 days in custody, if we remain there also, they were there, my lord, the charge sheet, it cannot be further developed by way of a supplementary charge sheet, my lord, with folded hands, my lord. Young boys, my lord, unfortunate, that should not have happened. And another aspect, my lord, my lord, regarding a postmortem report, I'm placing the postmortem report by blunt impact, my lord.
But none of that is available with learned PP now. Let us have the record then.
As your lordship pleases, my lord, can it be tomorrow, my day after tomorrow, my lord? Unnecessary, my
When
lord.
you get it?
Yes, my lord. Yes. Thursday, my lord.
Tomorrow.
No, I'm not tomorrow, my lord. Definitely not. I'm sorry, my lord. It just came out, my lord. Thursday, my lord, if
Because,
possible. Your voice, my lord.
a scan copy of the TCR through registry, my lord, it has to come. So, my lord, my
But
part. to
Mr.
say-
B.K. Mahajan, learned counsel for the petitioner, learned additional PP is submitted by learned additional PP that the scanned copy of the TCR would be necessary to make appropriate submission. Hence call for the scanned copy of the TCR. Is the matter again on 9th?
Oh, yes, my lord.
Oh, my lord, my lord. Highly obliged, my lord.
Madam, 1 and 37 same, madam. 1 and 37.
And 37.
1, 2, 3.
Obliged, my lord. Obliged. Obliged, my lord.
prison, 483 application, my lord. Total my detention was 100 days, my lord. And I was shown that case, earlier case bail was granted by your lordship.
Oh,
Now
that
in
car-
this case,
Deep
in this
Roy.
case, 61 days.
Deep Roy.
Yeah. My lord, because he is being shown arrest one after another cases because of the fact that he has his father has filed a complaint to the Human Rights Commission because of the torture made to him. And my lord, that will your lordship will get in page number 19 and as well as page 23, my lord, page 22 of the Human Rights Commission order. Now, my lord, statutory period is over 61 days, no charge has been filed.
Then what remains?
Today is 60, I will get after some time, I will get the instruction if search sheet submitted. Otherwise, I
I
will
didn't get the instruction. After some time.
Today at 2 p.m.
No, before 2 p.m.
Yes, before 2 p.m. I will.
I don't think this list will last till 2 p.m.
Wait, please, Your Lordship. My lord, I beg to draw your lordship's kind attention to the forwarding report at page 13, my lord.
1-3.
1-3, my lord. Apart from the forwarding report, your lordship will find that he has been completed 62 days in jail, my lord. And as such, the mandatory period of detention has already been over, my lord.
So any instruction regarding filing of charge sheet?
Matter also, my lord, I have no instruction, my lord. This matter may also kindly taken up at 2, my lord. I will get the. After some time also I can get it. my lord.
After some time.
After some time.
Whether charge sheet has been filed or not.
9.
Wait, please, your lordship. But here, my lord, earlier previous bail was rejected, my lord. Then she appeared, my lord, and surrendered, my lord. Now she is in jail, my lord. That case, lordship, page 9 is the FIR, my lord. Sure, my lord, now the my lord, only prayer, my lord, that is the her, my lord, child, my lord, 5 years old, my lord, is along with her in the jail, my lord. And a month in now she was arrested on, my lord, 5/12, my lord. Exactly 1 month in jail, my lord. After rejection of the pre-arrest bail, my lord, 1 month she is in jail.
Call for the CD.
My lord, page 18 is the forwarding report, my lord. Here, my it clearly my lord, shows that, my lord, her child, my lord, 5 years old, my lord, is also along with her in the jail, my lord. Page 18, my lord. My lord, the first paragraph, my lord, sir, with reference, my lord, then that, sir, the accused, namely Uma Das, Riya Das, has a baby, namely so and so, age 5 years. Her husband, namely so and so, refuses to take Jimma of the baby. Therefore, I forwarded the baby also along with the accused, my lord. So, my lord, she is, my lord, she is studying also, my lord. My lord, she is a student also, my lord, of a preschool, my lord, and she is, my lord. So, my lord, on any condition, my lord, because of 1 month in jail, my lord, father, my lord, custody may not be required, my lord, in this case, my lord.
Your husband has refused to take the baby, that is why he's like.
Man, he got pre-arrest bail, my lord. He has refused to take, my lord.
Then
He is a free man, my lord. My lord, on any condition, my lord, along with the child, my lord, now she has to, she have been informed, she has to sleep in the floor, my lord, in this cold winter, my lord. And on any condition, she will, my lord, face the trial, my lord, 1 month in jail, my lord.
since your husband has refused to take the baby,
Oh,
let
man,
us
he got
cancel his
pre-arrest bail.
pre-arrest bail. Let him also go to jail and take care of the baby together. This strategy will not work.
Actually, my lord, the relationship is, my lord, there is not cordial between the husband and wife, my lord.
All right, we'll have the CD.
Not so.
Call for the CD.
19-1.
Take-
19 on, oblige the lordship.
Here in this case, Lordship, NDPS commercial quantity, probably records will be required. And one thing is I'm pointing out before, Lordship, that tomorrow another co-accused bail application is pending where records are available, Lordship. Lordship may call for the records and maybe fix tomorrow, Lordship.
Submitted that bill application on behalf of co-accused is listed. Has been directed to be listed tomorrow. Is 6/1/26, hence release the matter again on 6,
Yes, sixth, Lordship.
6
Along with BA number 3814 of 2025. Oblige, Lordship.
Is the if anticipatory bail application is directed against the lodging of the FIR in Sunapur PS case number 130 of 25. But this is a second bail application. Lordship, I wanted to bring your lordship's attention to your lordship's order at page 28, subsequent prior thereto, Lordship, on 10/9/2025, this petitioner before your Lordship, Dipen Deka, was granted interim protection by this honorable court. The order is at page 23, Lordship. In fact, this petitioner has not been named in the FIR. And it is the co-accused statement based on which he has been implicated for receiving the stolen property, Lordship. Your Lordship will come to page 24. Therein the submission is recorded. Findings of the Honorable Court. And Lordship will then thereafter come to your Lordship's order. That page 27, your Lordship had recorded the content, the finding, but this itself, it is all based on the statement of the co-accused, Lordship. And similarly situated, petitioner was before this honorable court, and on 4/11/25, this honorable court was pleased to grant, your Lordship had in fact granted.
Which page?
Lordship, that order, my learned friend will please. Exactly in the same case, Lordship, where the informant was Pinku Kumar and he had lodged the FIR. based on mere suspicion, Lordship. Apprehending which the present petitioner has filed this anticipatory bail application, and at page 31 onwards, I have annexed the medical record of the petitioner. He had in 18 September 24, he was diagnosed of pituitary neuroendocrine tumor, because of which he underwent surgery in September.
That was this order you're referring to, that is in respect of one Kalyan Pator.
Yes, Lordship. In the same case, he has been implicated. Kalyan Pator.
No, that was based on the material available on the CD, nothing was there. That was why
Okay.
bail was granted. Now we don't know what is there against the Dipendeka, and earlier also the prayer was rejected by
Your Lordship.
perusing the CD. So we'll have to have the CD again.
But in the interim, I'm just praying for
How
interim.
can you pray for interim when it was rejected earlier?
Is suffering from pituitary neuroendocrine tumor, because of which he underwent the surgery in September, Lordship. Even otherwise, Lordship,
And the event took place after that.
Lordship, it's the co-accused statement, which is not admissible. And in Harisaran Kurmi, 64 Supreme Court, Your Lordship, Supreme Court had heavily come down on the confession made by co-accused, reliance placed on it. AR 64 Supreme Court 1184.
No, we don't know what is there. It is whether it is on the only on the confession or statements of co-accused or any other statement is there. Even after rejection of the previous bail application long back, he was still at large, is it not? So we can wait for a few days. Let us have the CD. Yes, when can we have it?
(21:20).
Learned counsel for the for the CD. Please the matter again on 21.
20, yes.
Much obliged.
Hey, please, your lordship. Lordship, this is a second bail application, lordship. Lordship, the allegation against the petitioner is that he has taken a loan, lordship, by giving some spurious gold, lordship. The rejection order is at page 23, lordship. 24 is right.
If it is rejected, we'll have to have the CD again. Hard learned counsel for the petitioner. If you call for the CD, list the matter again on
21:1.
The Caesar list may be called for, lordship, because
along with
I.
the CD along with the Caesar list.
idea আমি
16 CD কল করাই না আজি হে আছে
Your Lordship, call me CD.
Now let's say on the call for the CD. List again on.
yes 22 22
17.
Please, your Lordship. Here, earlier rejected. At this stage, I pray, Lordship may only call for the up-to-date case diary.
All right, after that CD.
Obliged, 18 not a similar order, my lord,
All right, same.
up to date similar. Obliged, my lord.
May it please, your lordship. Lordship, the herein no FIR is there, lordship. But the police person from the Rongya police stations are calling the petitioners numerous time, lord, without issuing any notice, lordship.
Had learned counsel for the petitioner, learned additional CP to obtain instruction as to whether any FIR has been lodged against the present petitioner is Digon or not. When can you get it?
On my lord,
It's only instruction,
9-1, my lord, on,
9. Again, on 9.
In the meantime, the person will be protected, lordship.
The protection can we give in the meantime?
Obliged, your lordship.
earlier rejected, my lord, that we can call the case down, my lord,
CD.
on 23.
21.
For timing, my lord. 21.
Well, timing.
22.
Lordship, matter may be passed over for time.
23.
Yeah, please, lordship. Lordship, the allegation is for kidnapping, lordship. There's a dispute PS case number. Call for the CD, lordship. 5 of the accused, lordship, is already enlarged on bail, lordship. So his name was not in F. In the course of investigation, he was arrested, lordship. Enlarged on bail on page 16, lordship. This is the lordship order, lordship.
All right, CD.
Peaceful, lordship, in a short time. Short days, lordship. Peaceful.
Hmm?
Peaceful PS, lordship, in the short time. All right, lordship.
Yeah.
That's it.
In this case, can copy of TCR was called for not yet received.
None appears for the petitioner. Scanned copy of TCR also has not been.
27 item. But sir, today is fixed for CD and it was strict direction to ensure that CD should be on record.
Earlier, my lord, by order dated scan copy was called for, my lord.
Lordship, it's almost more than 3 months of filing of the
28/11/25, my lord, by order dated 28/11.
since last 4-5 dates.
Charge sheet already submitted, my lord.
It was submitted without
Yes, Lordship.
FSL
FS,
report.
without FS.
So whether charge sheet has been resubmitted,
Not yet, Lordship.
My lord, I have no.
this is Kamrup Metro.
Kamrup Metro.
Lordship, yes. My custody is nearing to fault limitation, Lordship. I may be hard. My involvement is not there in the
When is the statutory period?
Lordship. It's 6 months. I have been in custody for more than 150 days, Lordship. Nearing 160 days is the, and 180 days is the.
Statutory is 180.
Statutory 180. Lordship.
180. On 31/10/2000, that is the order of the trial court on 31/10, my lord. Thereafter, my lord, immediately, whether charge sheet file again after with the FSL or not, my lord, that record I will have to.
Lordship, on the last occasion also, it was
Already heard. Learned counsel for the petitioner. Yes, and also learned additional PP. It appears from the orders certified copy. It appears from the certified copy of the order dated 31/10/25 passed by the learned session judge Kamrup M. That so the charge sheet was submitted, the same was not accompanied by the FSL report, and accordingly the charge sheet was returned. Full stop. Learned additional PP submits that he is to obtain instructions whether the charge sheet has been resubmitted along with the FSL report. So it appears that the scanned copy of the TCR was called for, and per office note, the same has not been received. Learned Session Judge Kamrup Metro directed to submit the transmit the scanned copy of the TCR along with the charge sheet if submitted fresh. Registry to do the needful.
In the meantime, may I pray for interim.
Is the matter again on 9th, okay?
See, with the meantime, may I pray for interim Lordship? He's more than 5 months, he's behind the bars and his age is nominal Lordship, 21 years. What are you
Is the point of fixing it on 9th then?
Fine.
Twenty-nine. Oh, আপনার 29.
Lordship, make clear, Lordship. Actually, it is behind the bar for last 7.5 months, Lordship. The main story is that the girl and the boy are in love affairs. The minor girl come to the residence of the petitioner here. And on refusal by his parents and on insistence that she wants to marry, the parents refused that she is a minor later and informed her parents. And accordingly, on the next day morning, the parents of the girl came and take her back. And subsequently, that marriage could not be performed due to minority. They have lost this FIR, Lordship. Evidence of the victim and 3 other witnesses have already been completed, Lordship. The main, if your Lordship goes to the statements, simply it comes that she came to the, no question of kidnap also, Lordship. Both are in love affairs. And some allegation has been made which we have denied, Lordship, regarding physical relation. On that day, she was in our house. That is admitted part, Lordship. She was in our house, which she slept with her parents. And on the next day morning, the villagers came and accordingly the girl was handed over back. And considering the period of detention, Lordship, trial almost going to our total, there are 9 witnesses. We have annexed the 164 statement also of the victim at page 17, Lordship. I am presently studying. May I read, Lordship?
Yes, yes.
Page 17, Lordship. I know Manas Pathak from a long time and we have love affairs. The day before yesterday, he took me to his home to Manipur to get married. I stayed night with him. We had physical, this part we are denying, Lordship. That is not true, Lordship. She stayed in our house, that we are admitting, Lordship. And next day we have handed over her back. Yesterday, my parents brought me back from his house and we came to the police station. Moreover, Lordship, in this case, if your Lordship look at the notice under 47 and 48, the only allegation that victim has been recovered from your house. No mention regarding any physical relation, nothing else in the 47 and 48 notice, Lordship. Apart from evidence of prime witnesses has already been over, Lordship. No chance of any hampering and tempering of the evidence or trial. We are ready to cooperate with any condition, Lordship. We may be allowed to go on. He is a very young boy, Lordship. He is a boy of 22 years. And behind the bar for last almost 7.5 months, more than 7.5 months. Evidence of victim, her parents have already been over, Lordship.
Actually, kindly page the PW2 the victim statement. Yes, the position, what happened, what he did, my lord.
Those are all exaggerated versions, Lordship. Nothing in 161, nothing in 164.
No, regarding commission of sexual intercourse, that has been stated in a statement before the magistrate
There, no, but we are
and before
denying
the
it,
trial
Lordship.
court also.
We are denying it, Lordship. That part is there. That part is there, Lordship. But once in.
What more
if
is
your
required?
No, Lordship, if goes to the section 47 notice, Lordship. Page at 26, 25, Lordship.
Whatever it was found during the investigation and in the
Even
deposition
that
of
part
the
has been
police
violated.
supervisor.
Vihan Kumar has not been complied with, Lordship, here. If that part has to be considered. We have mentioned in page 23 that translated copy, Lordship. You are hereby informed that the minor girl Ainu Bordoli has been recovered from your house along with you. Therefore, for the above mentioned reasons, you are being arrested. At page 23, we have given the translated copy, Lordship. 24 is the vernacular copy here.
That was the ground.
Latter part, then
Let-
he well know.
My own notice is not the informant, Lordship, it is the violation of constitutional right, Lordship. Same is with the 48 notice, Lordship. Page 25. Ground of arrest, you are hereby informed that minor girl body has been recovered from your arrested person's house. It is not a fact that this has been, I have been arrested after recording the statement of the victim. So the only allegation has been brought against me in the 47 and 48, only that because the victim girl has been recovered from my residence. And that cannot be an offense, a minor, recovery of a minor, when she come to my residence. Even as Varadarajan judgment is also there, accompanying a minor is not an offense.
It is the matter of trial, my lord.
A
and
trial has already been
here
started, victim
started, my
evidence has
lord.
been recorded.
Search frame, my lord, informant and victim examined. As per my lord, record, my lord, it is up to 1611, my lord. Then what is happening, that is not here, my
That
lord.
is major, they are the
Last
informant. of the
order is
victim.
13/11/2025.
They are the prime witnesses.
Let me see, let me. 13/11/2025, my lord, last order, my lord. Here it is next date on, see, 26/11, my lord. In the record, my lord, only 2 witnesses statements, positions are there, my lord. Informant and
Mother was
victim, my lord.
examined, subsequently
But,
mother was examined.
up to date not available, my lord. And from the evidence of my lord, situation of the victim, my lord, it is clear case, my lord. It is not a fit case to grant him at this stage, my lord. Some of the witnesses, vital witnesses are yet to be.
Vital witness will be, victim is the vital witness, parents are the vital witness, they have been examined, informant is examined, Lordship here.
No, if
But
we
it
are,
is more
if we are to go by the material on record, then material is against you anyway.
See, that's why I am coming here, Lordship, on the violation of the 47 as well as the mercy of the court, Lordship. Because of the period of detention, he is a boy of 22 years, Lordship. Admittedly, they are in love affairs. Admittedly, that part is not there. It is a case of any false personation, nothing like that, Lordship. Both are in love affairs. That is admitted part. I am in love affairs.
Married also.
What
No,
is
no,
the
not
date of recording
not
of the
at all.
statement of the victim by the police?
161, Lordship.
Yes.
I don't have the copy, Lordship. I have the 164 copy. I have annexed here with Lordship. That is page 17, Lordship.
What is the date of arrest?
9/6, Lordship. 19/6. 7.5 months, Lord.
A magistrate statement that is also on 19/6.
Yes, Lordship.
Police
After,
statement will
after
also be on
recording,
the same day.
after recording her statement, I was arrested, Lordship. After recording her statement, I was arrested. There should have been a mention.
Now, how do we know that you were arrested there? after the recording of the statement.
No, that is the.
Policemen found her there, they
Otherwise,
arrested you.
Lordship, it is not the affair of a, it is a simple affair of a kidnap only, Lordship. It is the simple affair of a missing girl. May I read the affair at page 16, Lordship?
At the time of arrest, whatever ground was available to the police was
My lord,
furnished
that
to
is
you.
mentioned in the my lord.
Subsequently, that-
টিউশন করে যাম বুলি ঘৰৰ পৰা ওলাই যায় বৰ্তমানলৈকে ঘৰত ঘূৰি অহা নাই nothing mentioned regarding accused is not an FIR name, Lordship. Page 16 is the FIR, Lordship.
that has gone.
We have informed the police. We have handed over the victim to the parents of the victim by calling the parents of the victim. We have handed over.
But is all right, we are only, since you are submitting violation of 47-48, we are delving into the matter.
Lordship, I am mainly on the mercy of the courts, Lordship, because the period of detention, his age. He is a very tender age boy, Lordship, keeping him in jail with the veteran criminals.
But offense are in heinous nature, my lord. What he has done, my lord.
Yes,
Lordship,
Or to such a-
all right, let us see. I may become more merciful in the afternoon. Yes.
Lordship.
Chamber.
My lord, here lordship, as per my lord, office note, my lord, 2012, my lord, service complete, my lord.
Yes.
Yeah, it is also section 4 box.
75 days in custody, Lordships. TC already received, Lordship. FIR page 12.
Is the affair?
Page 12, Lordship. May I read the affair, Lordship?
Yes.
নিবেদন এই যে মোৰ 17 বছৰ 9 মহীয়া ছোৱালী মিছ ৰেশমিয়াৰা বেগমক যোৱা নিশা ইংৰাজী 13-10-2025 তাৰিখে 11:30 মান বজাত মোৰ ঘৰৰ ওচৰত থকা পদকে ৰাজু আলীয়ে তেওঁৰ ঘৰলৈকে মাতি নি যৌন সংযম কৰে বুলি মই মোৰ ছোৱালীৰ পৰা গম পাওঁ গতিকে উক্ত পদকীয়াজনৰ বিৰুদ্ধে বিহিত ব্যৱস্থা লোৱাৰ বাবে এই এজাহাৰ যোগে মহোদয়ক পঠানো দিছ ইজ দ্য এলিগেশ্যন, লৰ্ডশ্বিপ। Her age is 17 years 9 months.
As the service is complete, my lord, lordship may point one amicus curiae, my lord.
Service is complete.
My lord, service complete, my lord. As per office note, my lord, 2012. my lord.
Business dated.
My lord, service, office note 2012.
If service under respondent number 2 is complete.
Fine.
None appear. Respondent number 2. So and so is appointed as number 2. TCR has already been received. Scan copy of TCR has already been received. Leave the furnish copies to the learned amicus curiae. The matter again on.
8 mile 8 notes. Long vacation.
19, my lord.
I think you have been implicated by the victim.
My lord,
Yeah.
my lord, that is.
Was a bit after the vacation. List the matter again on 21.
Fine, 21, my lord.
Mine 19.
19.
19.
Blank.
Maybe you lost one. Second time, madam, you also are rejected. At this stage, madam, I pay only, madam, city may be called, madam.
All right. CD.
Date my birth,
Give it date.
Then that
can it be the wrong year, madam?
21.
21.
19.
Some খোলা দিনা, খোলা দিনা,
Oh,
আকৌ
19 আছে স্যার।
21, na? Published.
Item 21,
I may be allowed to withdraw, my lord. There is some mistake. My lord.
Honorable Learned Counsel for the petitioner, Mr.
Isar Ahmed.
Sir Ahmed. The petition is dismissed as withdrawn.
Obliged, my lord.
TCA received.
My lord, here CD part is not available, my lord. Lordship, may kindly page the 31, my lord. CD part is not available, my lord. Only 183 statement is available, my lord. And
I think Mr. Chaudhary was
My
there
lord.
in this case also.
no, yes. Is not well, no.
TCR has been received, but
Scan
scan
the
copy of
case.
CD is not available.
My lord, scan copy of the case there, no.
Call for the scan copy of the CD. Again on.
First. My lord, it will come through registry, my lord. As search sheet already submitted, my lord. As search sheet already submitted, my lord, it will come through registry, my lord.
The registry is directed to call for.
I please lordship. 483 application lordship. Number?
32.
So,
My lord, here also as per office note, my lord, service complete, my lord. 2012, my lord.
as per office note dated 2012-25 service on correspondent number 2. Complete, however, none appears. So and so pointed as amicus curiae to present the respondent number. A copy be served upon the amicus curiae, release the matter again.
Amicus also.
Amicus, give the name.
My lord. My lord, 22nd, my lord. 22nd.
You get the name and serve the copy.
All right.
33.
The case diary was called for, it's a case pertaining to seizure of intermediate quantity of ganja, 7.135 kg from a 19-year-old boy. Now, the problem is there, my lord, they have also invoked section 27A, which is regarding financing. And neither the FIR nor the forwarding report discloses anything regarding financing. But because 27A was there, so CD was called for. It will be the third occasion CD has not come and petitioner has already completed 60 days in custody. If 27A goes, my lord, his statutory period gets over. May I pray, my lord, the last opportunity may be given and maybe fixed on 9th, my lord.
Which police station is this?
Hujai, my lord.
Huh?
Hujai, my lord. Hujai, my lord, in every case, my lord, NDPS, whether it's small quantity, intermediate or commercial, 27A is invariably added. FIR is at page 11, my lord. Nothing there in the FIR, even in the forwarding report at page 13, my lord, regarding financing.
May I prefer short that, my lord. I will try to put this.
CDS call for has not been received despite earlier orders. Dated 25/11/25, 5/12/25, and 17/12/25. OC Hosai PS is directed to ensure submission of the case diary on the next date fixed, failing which he shall appear personally before the court. Place the matter again on 9.
I'm deeply aware.
Communicate this order to the OC Hosai PS.
Lordship. Lordship, FIR page 11, Lordship. Petitioner is 22 years old, Lordship, in the work for 90 days. It's 11, Lordship, FIR. 90.
But as per my CD is available, as per my instruction from the IO, FSL report not received and search sheet not yet submitted. Today is 89 days, ma'am.
I have
90 days.
Today is 90 days lordship as on date. Lordship. There was lab affair lordship actually. And
CD is available with us. ma'am.
What is the age of the victim?
16 years as per FIR lordship. 16.
Yes, what is your statement?
Lordship, the victim committed suicide lordship.
Okay, sure. But this is,
As per allegation
I
lordship,
thought this was POXO case.
yes lordship. But there is nothing lordship. FIR is at page number 18, my lord. The basic allegation is that 13,50,000 rupees has been credited to the bank account of the present petitioner, my lord.
So what do you have with you right now? The case there is there.
A case there is there, my lord, CD up to, my lord, CD is up to 29/10/25.
In
29/10/25.
calculate question.
And what is the material collected till then?
Those, my lord, articles were recovered from the present petitioner, my lord. And then petitioner was earlier, my lord, arrested on the basis of an, my lord, ZDNT, my lord, which was registered against him in a cyber offense case in, my lord, Bihar. And thereafter, during house search, my lord, house search of the present petitioner, these, my lord, items were recovered, my lord, from the present petitioner, my lord. I will point out, my lord.
Items means which items?
Yes, seized one ICC, I examined materials, I will point out, my lord. During the search operation, the accused Raju Ahmed plead from this living behind several eliminated. The said materials were seized by the articles. One HP laptop, one 16 GB Sony pen drive, 4 mobile handset, 10 rubber stamps of different foundations and institutions, bank passbook, checkbook, debit card, 4 ICCI bank statements, my lord, crypto investment forms, NGO documents, and fake commitment letters. After the seizure, my lord, the IO examined the materials and made inquiries with the ICICI bank officials, namely so-and-so, zonal head and branch manager, who confirmed that the seized ICICI bank documents are forged and fabricated. It was verified that the account number format so-and-so, my lord, your lordship may kindly. My lord, CD needs to be updated, my lord, only up to 28/10, my lord, regarding.
Petition was
other
filed
materials
after
we-
the date, it was filed on, bail petition was filed on 17/11, my lord. So far the, my lord, CD is concerned, my lord, some articles has been seized, but what is the investigation, what they found, my lord, because, whether by using those documents, which my learned friend has already pointed out, my lord, whether I have cheated anyone. Because I have, regarding bank account, I have stated in my petition, my lord. And so far the main allegation 13,50,000, my lord. From that Sonu Kumar, my lord, Sonu Kumar, no? Sonu Kumar, no such transaction was made in the account, any account of the present petitioner, my lord.
And
How
by
soon can you
using-
get the updated CD?
Yes, my lord. Otherwise by using those, my lord.
It was rejected earlier, is it?
No, my lord, no. It is a first anticipated bail petition, my lord.
First.
Yes, ma'am.
Your lordship was pleased to grant bail to the wife of the present.
Wife of the
petitioner.
petitioner was made as
Because
accused, my
against
lord.
the wife of the present petitioner, there is no such material, my lord.
I want to cooperate, my lord, but I am not in interim, my lord.
On the ground.
Seizing some documents does not prove that I am guilty, my lord, but whether I have cheated anyone, my lord, whether any transfer has been made in my account, that is the issue, my lord.
What is the information available in this regard?
Regarding,
Any
my lord, that
transactions?
aspect, some, my lord, materials after 28/10, what happened actually, what are the materials, recent developments, my lord? Otherwise, he, my lord, in the name of some running some NGO and institutes, my lord, by way of using, my lord, those institutes, by using those fake, my lord, ICCI documents, he lured the customers from the outside state, my lord, and they are after, my lord, involved in committing all these cyber offenses. And regarding that case, my lord, in Bihar case, total 13 lakh 50,000 rupees deposited in his account, my lord.
My lord, I have annexed the FIR of the
after, my
Bihar
lord.
case, my lord. That does not
Bihar
disclose
case.
that any amount was credited in my account, my lord.
That is, my lord, not in directly in his account, my lord, in the institute, my lord, which is running by
Now
President
said in my account, now said,
Updated CD.
Raju.
For the,
because it is a long pending case, my lord, in third time, my lord.
they have been out for a long time also.
A short date may be given, my lord.
Yes.
On, my lord, 22/1. That 22/1.
Can it be on 21, my lord?
21.
Yes.
Call for the updated CD. FSL report.
Interim may be considered on next
Well,
date.
IO may
It
be
is not a-
specifically directed to, my lord, submit the updated CD without fail on next date, my lord.
You write, Heartland Council for the petitioner. Updated CD. FSL report as called for has not been received. The IO is directed to submit the same positively by the next date fixed. Matter again on 21.
Fail, my lord, my interim may be considered on next date if next date. I have failed to produce the updated date CD, my lord. Otherwise, it's the third time, my lord, CD.
Make that submission on the next date, yes.
Highly obliged.
Yes.
May it please the lordship. Lordship, CD perhaps received by this honorable court. FIR, your lordship will find at page 7. Page 7. May I read, my lord?
Yes.
Most respectfully, I beg to inform you that on 21/9/2024, at about 10 a.m., the below named accused person kidnapped my daughter, date of birth 3/8/2013, from my own home in Badlangmari village without informing us and hide her in an unknown location.
Kidnapped her without informing her parents.
Without information of the parent. My lord, the fact is that here the allegation is kidnapping was caused on 21 and the affair has been lost on 27. So lordship, this is unusual that a minor girl of age 12 or 13 years is being kidnapped and they are not informing to the police station. And they even do not know whether the alleged accused person has kidnapped or not. This is merely on assumption, lordship. The accused person has been named in the FIR. Otherwise, the accused person is no way connected in the entire episode, my lord.
Your lordship may kindly peruse that flag mark portion, my lord. Victim, my lord, already, my lord, that one skull was found suspected to be the, my lord, skull of the victim, my lord, but regarding that DNA, but identified, my lord. Only that flag mark portion, your lordship may kindly. After also, my lord, PM report, DNA profiling, my lord, next.
So has the identity been established
Not yet, my lord.
Identity, my lord.
of the victim?
Victim not yet established. my lord.
Not yet established.
Some time, my lord.
My lord, the present petitioner, the alleged accused, is also 21-year-old boy. Lordship, the only issue is that this petitioner used to talk with the girl, and the last call the petitioner called to the girl was in the month of January and February of 2025. And the victim and the informant's family, Lordship, they are relative only. I have mentioned in my petition.
There appears to be nothing connecting him there.
Whereas, my lord,
These two
the-
statements that they heard.
that skull was recovered and whether the identity of that skull is the victim, how he linked, my lord, regarding those aspects, my lord, till now.
Otherwise, information we have received that this particular body was recovered from the informant's nearby place only.
But allegation is that, my lord, victim went out along with the present accused person. That is the contents of the FIR, my lord. And
No, so they said
Samir Nam Fulsan Ali. He is the, my lord, Fulsan.
My name is there in the FIR, but I have kidnapped. No one has seen, no one has informed.
আমাৰ অজ্ঞাতে পলুৱাই অপহৰণ কৰি লৈ গৈ কোনোবা অজ্ঞাত ঠাইত লুকুৱাই ৰাখে regarding that.
what is the name of the informant?
Informant is the my lord Surman Ali, father of the
Father of the
father,
victim.
and my lord accused is Fulsan Ali, the present petitioner.
And Lordship may see that
Surman Ali. Where is the statement of Surman Ali?
Surman Ali.
My lord, the petitioner shall cooperate with the investigation.
Surman Ali's statement is also not there, I think.
I will point out, my lord, if there is complaint in, my lord.
It has also not been ascertained, my lord, whether the
Otherwise,
person, dead body
only
is belonging
in
to the victim
FIR
or the
it's
daughter of the.
stated he is the prime suspect. Otherwise, my lord, because victim eloped with him.
Case of the FIR, it shows that the incident took place on 21 and the FIR has been registered on 26. It itself creates some doubt that why a parent lodging the FIR to the police station after 7 days, if they are very much certain that the present accused person has kidnapped the daughter. And more importantly, the age of the daughter is shown 13 or 12 years, my lord. I have categorically stated, Lordship, that the last call the present petitioner made to the girl was in the month of January and February of 2025. Thereafter, Lordship, the petitioner never contact with the girl. That there cannot be enough ground, Lordship, to arrest the petitioner. Lordship, the petitioner will definitely cooperate with the investigating agencies, Lordship.
The FSL report is not there.
Otherwise, my lord, this is anticipatory bail. My lord. The present petitioner is the FIR named accused. Allegation is that the victim eloped with him. Although, my lord, otherwise also, my lord, if that body is not of the victim not yet, my lord, recovered also. If that, my lord, skull was later on found to be not of the victim, my lord. His main allegation is against the present petitioner that till now, he is the prime suspect. Was victim eloped with him and thereafter now that skull is suspect.
But the informant has lodged the FIR after 7 days. It is not understood, Lordship. Some details should be mentioned in the FIR. They have not.
Of 7 days in this type of.
My lord may kindly consider the bail petition at this stage, my lord. I will definitely cooperate with the investigating agency. Any condition may be imposed by this honorable court will be obeyed by the present petitioner. The present petitioner is of 21 years old only.
Age of the victim is only, my lord, date of birth 3/8/2013. My lord. Yes.
In absence of specific allegation or findings against the victim, lordship, his liberty enshrined under Article 21 may not be denied at this stage. My lord may kindly consider what is the involvement of the present victim in the entire issue.
It is a merely, basically it is
Otherwise,
suspicion.
one aspect is also there, my lord, probably for recovery of the victim, otherwise for identity of that. Also, my lord, his statement is required to be recorded by the police, my lord. Otherwise, my lord, without his recording, without his, my lord, interrogation, my lord, it would be difficult to, my lord, find out whereabouts of the victim, because allegation is that he eloped. So let him, my lord, without granting any, my lord, disposing of the bail petition, let him, my lord, first appear before the my lord, arresting authority, let him recording his statement, my lord, at this stage, my lord, considering the, my lord, peculiar circumstances.
Heard learned counsel for the petitioner and learned additional PP. This application has been referred seeking pre-arrest bail on behalf of the petitioner Fulchan Mondal alias Fulchan Ali. The allegation as contained in the FIR 26/9/25 that on 21/9/25 the petitioner kidnapped the minor daughter of the informant aged about 13 years. Yeah. It appears that the from the material available in the CD that what was recovered, one skull.
Yes, sir.
One skull was recovered. From a forested area near the house of the victim, and certain items were seized and sent for forensic examination, but no FSL report is available. As per the CD, appears that the petitioner has been named in the FIR on the basis of suspicion, as the victim had a relationship with the petitioner. Having regard to the above, is provided in the interim that the petitioner sues based on interim pre-arrest bail of 1,000 with one surety. Like amount to the satisfaction of the arresting authority. Is arrest in connection with the so case number. It is directed that the petitioner shall appear before the IO within a period of 7 days today for recording of his statement. And beg the CD to be resubmitted after recording of the statement. Petitioner on the next date fixed, list the matter again on 23rd,
28-1, my lord. 28-1.
28/1.
Oblige, your lordship.
26.
May I please, lordship? My lord, CD was called for along with
CD.
PM report.
Did you receive, my lord?
Allegation is that some boys, including the present petitioner, killed her, and mainly ground was that may be seen page 9, last 6 lines, my lord. On 10/10/25 at around 7 a.m. in the morning, Kalu's dead body was found at Nimtuli River, Moradhonsiri, which is nearby Elias' house. There was about 30-meter distance between Elias' house and the river. Kalu had injuries on his dead body. I suspect that Elias, Ali, Mum, Tulal, Gulu, and Shamraz had killed my son. So this is the doubt. Now, my lord, may I kindly see the postmortem report. So far, the accused, out of intoxication, he drowned in the water and thereby died. As is informed by my party, only suspicion that as the dead body was found near by my residence, that too within 30 meters area, then it was doubted. But there is no reason why I will kill a person.
Yes, PP.
My lord, I have received the case there, my lord. Lordship, although my learned colleague read only the last part of the my lord FIR, my lord, but earlier part there is a allegation against him also, my lord. And reportedly he is the my lord, one of the my lord peddler, my lord, drugs peddler, my lord. And from the PM report, my lord, I am coming to the PM report, my lord. Several injuries are there, my lord. Even though he said that, my lord, in intoxication he has, my lord, drowning, my lord. But here is the, my lord, from the PM report, several injuries are there. And from the opinion, my lord, in opinion, my lord, doctor's opinion, my lord, it was clear, my lord, death was due to coma as a result of injuries sustained over the head as described. All the injuries were antemortem and caused by blunt force impact, my lord. Here, although it was sent for FSL, my lord, viscera, it was FSL report also received, my lord. Here in the FSL report, my lord, no poison was detected. And it is the clear, my lord, murder, my lord.
So,
And there, my lord, there
murder
from the
may
statement of
take
the
place, my lord.
accused, my lord, and witness, my lord. All of them together along with the, my lord, disease, my lord. And it was seen by the witnesses, my lord. And thereafter, there some shuffle or altercation there. Thereafter, he was.
Where are the statements?
My lord.
Witnesses' statements?
My lord. And one of the witness, my lord, crime scene of my lord, here, so dear my lord. I have checked my hand.
Rehana Begum is not a witness, eyewitness.
My lord.
Is Rehana Begum?
No, eyewitness, no, dear my lord, a complainants and witness.
This Azhar Ali is crime scene witness.
My lord.
But my submission is that there might be some injuries, but whereas those injuries are sufficient for the death of that person or he drowned in the water. What are the main reasons?
That is what is said in the PM report.
My lord, my lord.
Okay, we'll see.
Not a case, my lord, from my objection is there, my lord.
Um,
To grant him bail at this stage, my lord.
All right.
Lordship, in this matter, Your Lordship, petitioner has been arrested, Your Lordship, following the mandatory requirements uh, formulated by the Honorable Supreme Court in Probir case and Bihan Singh Lodge. Also, Your Lordship, although FIR in the FIR, Your Lordship, section 21C has been, but the suspected quantity falls under the intermediate category, Your Lordship. 116 grams only, Your Lordship. And that fall under the intermediate category, Your Lordship. I have annexed the arrest memo and mention inspection memo, Your Lordship. Kindly peruse page 33, Your Lordship. No grounds of arrest have been. Also, Your Lordship, in the notice under section 47 and 48 also, Your Lordship, grounds of arrest has not been communicated to the petitioner and his. As on today, Your Lordship, here in the bar, behind the bar, 318 days, Your Lordship.
47 notice on board.
Yes, PP.
Getting 47 notice, that notice is there, Lordship, then it may not be the explanation, Lordship, that grounds of arrest is not explained. Others, Lordship, if you Lordship kindly go through the 161 statement, Lordship, he is a habituated offender. And earlier also he himself has admitted in his 161 statement that Lordship, he is also involved in some other such type of offenses, Lordship.
But as per the Supreme Court,
So there is no compliance with 47.
no, you.
I have also checked whether he has been immediately represented by any counsel, whether he is demonstrable prejudice or not, Lordship. That part I checked, Lordship, but he is not immediately engaged, no counsel appeared on behalf of him.
On to the 318 days, Your Lordship, till the charge has not been framed, Your Lordship. He will appear and face the trial, Your Lordship, considering the length of detention, Your Lordship.
There is absolutely no notice.
Dear Lordship.
Huh?
47 notices, dear Lordship.
Page?
That is, they have not.
I have not, it is in the records, Your Lordship.
It is on the record. I have
You have
checked
not
it.
annexed, then you are submitting on that basis.
I have checked. The arrest memo and inspection memo, Your Lordship. There is no ground of arrest. I have annexed page 33, Your Lordship.
On they should.
Arrest memo, ground of apprehension as per forwarding. And when is he going to get the forwarding report?
Arrest memo is not not providing to the arrest memo.
Arrest memo. So the Your Lordship, quantity falls on the intermediate category, Your Lordship, but FIR and the charge sheet has been filed under section 21C, Your Lordship. Kindly pay with the FIR, Your Lordship. Page 15, Your Lordship. 116 gram, Your Lordship, suspected quantity. Your Lordship.
All right, heard learned counsel for the petitioner. LPP. The allegation against the petitioner is that what is the quantity?
116 gram heroin, Your Lordship.
116.
116.
116 grams of heroin was recovered from the possession of the accused. It is submitted on behalf of the petitioner that the case has been registered under section 21C, 21 within bracket capital C, stroke 29 NDPS Act. The is quantity comes within the category of intermediate quantity. Hence, section 21C attracted. The aforesaid fact is not disputed. It is further submitted that there has not been sufficient compliance with section 47 stroke 48 BNSS. Perusal of the aforesaid notices clearly indicates that no grounds of arrest have been communicated to the accused or his relatives. In the arrest memo does not disclose any ground of arrest. It is simply stated against the said column. The grounds are as per the forwarding report. is also no material to show that the state forwarding report was furnished. The arrest memo, petitioner or his relatives in regard to the above. Yes, that the directions of the Honorable Supreme Court in Kumar, State of Haryana. Citation to leave. Has been clearly violated. 2025 SCC online SC 269. Having regard to the above, the prayer for bail is allowed. The bail of rupees 50,000 with 2 securities of like amount. Satisfaction of the CGM Kachar. Aforesaid case. Provided that the petitioner shall cooperate with the investigation, shall not try to hamper the investigation or tamper with the evidence. Petition stands allowed accordingly. Send back the CD. This scan copy. Index CD na lage. Yes.
May appeal your lordship. FIR is pays 10 million. AI generated FIR million. I'm reading the FIR million.
It is received.
Milord, in this case, Milord, informant's brother
Yes, what PM report is there?
We put it here, sir. And as per that losses, it was due to date was due to asphyxia as a result of antemortem suicidal hanging. Except the complainant statement, lordship, I have not found any material against this person. Complainant itself, he herself has stated, lordship, in his 161 statement, that lordship, the deceased person, after having some altercation with his boss, employer, lordship, he came back to the house of the complainant and he stayed there for 1 month. Thereafter, he again went to his work. He again returned back to his place where he.
Under the present petitioner in Guwahati, and on his last working day, he was assaulted by his employer. That is the petitioner. Thereafter, he was dismissed without salary. Thereafter, deceased exhibited signs of distress and depression. And subsequently, the deceased came to an untimely death. Peruse the CD. It appears that just from the postmortem report that the deceased died by hanging. there appears to be no material attributing any proximate or direct role to the petitioner as far as commitment to suicide is concerned. Considering the above, therefore, nearest bail is allowed. Directed that the petitioner sues himself. Nearest bail of rupees 50,000 with give like amount to the satisfaction of the arrest. Case number. Further provided that the petitioner shall cooperate with the investigation.
Standing.
Bless.
When my lord charge sheet not yet submitted.
Charge sheet not been
Charge sheet
filed.
not yet submitted.
Statutory period is over.
No, my lord, today is 60 days, my lord.
61 days, my lord, to my calculation. He was arrested on 28/9, shown arrested here. And earlier, he has completed total
Yes,
100 days
61.
because he was in another case.
Learned counsel for the petitioner, learned additional PP. Submitted by learned additional PP that charge sheet has not been submitted in the case. And it appears that the petitioner has already completed the statutory period of detention. Having regard to the above, the prayer for bail is allowed. 20,000 one. 50,000.
CGM Kamrup Metro. Development.
May it please your lordship.
So in this case, charge sheet submitted, my lord. Submitted.
My lord. May it please your lordship.
Earlier rejected, also rejected by your lordship.
Is correct, my lord. Lord, my lord, with all respect, I will submit. Charge sheet will be submitted in the Chief Judicial Magistrate Office. Here is no available, not available the charge sheet, my lord.
Huh?
That is inform that, learned people inform that this charge sheet has been submitted. But charge sheet has not been placed before this honorable board. So, my lord, till receipt of the summon, this accused person, if charge sheeted, definitely he will get summoned. Till then, he may be released on bail, considering the fact that he has been detained in jail above 60 days, my lord. 62 days. 63 days, my lord. With certain condition, my lord, he is a local person of Maligaon, Guwahati, and teacher of Paramedical Institute at Kahilipara, my lord. Having his children there at residential place. So, with certain conditions, till someone received from the learned court below that his charge sheet has been submitted, may be allowed to release on bail with certain condition, my lord. For 60 days, he has been in jail, my lord.
Where is the earlier order of rejection?
Page 19, my lord. Starts from page 18.
Statutory period is what?
Statutory period is on search sheet submitted on 30/12/2025.
30/12.
30/12. This case, Your Lordship, he in fact provided the upcoming question papers of the upcoming examination to the, not only in case of one student, 3 students, madam, their statements also. He being the teacher of that institute, madam, committing all these offenses, madam.
Not, all respect, my lord, as learned people submitted, that is, there are some serious allegation. There may be some serious allegation, but we did not deny it. But we are praying for simply bail, my lord. With certain conditions, my lord, at least, considering the fact that he is a local resident of Maligaon, Guwahati, and a teacher of institute. So there is no chance of his avoiding trial.
Page 18, earlier order. There are 1, 2, 3. Having an earlier bail application on behalf of the present petitioner was rejected by order dated 3/12/25. Para. Since then, the petitioner has completed 60 days in custody. And it is submitted by learned PP that charge sheet has also been submitted in the case. Para having regard to the above further detention of the petitioner may not be necessary. Accordingly, the prayer for bail is 50,202. It is further provided that the petitioner shall regularly appear at the trial if one commences petition disposed of. He received
48 CD not received, madam.
He did not receive. List the matter again on when?
My lord, 22 on.
Short date, Lordship, 19th.
On 20.
Yes, next. Give any date 20 minutes.
20.
Please, Your Lordship. Lordship, this is for amended cost title, Lordship, which I have filed, Lordship. I'll furnish you. I undertake to furnish a copy to the council for the CBI. Previously, Lordship, Director General CBI was made a party. However, there is no Director General. So Director submitted the amended cost title. Furnish a copy to Madam Lordship.
Submitted by Mr. R.K.D. Chaudhary that amendment application with regard to the cost title has already been filed. Copy of same be furnished to Learned Counsel for CBI.
Amended cost title has been filed.
Amended cost title.
First title is required to be amended.
That has been filed, Lordship.
So there is a, we can do it today itself.
It's up to my brother, yes.
Lordship.
Can allow it today itself. What is there? We only need to pass an order that instead of Director General, it will be read as what, Director?
Oh, yes, Lordship.
Yes, it can
Yes.
be.
Furnished to earlier. Having perused the same, it is
Test to দিয়ে দিলে হয়ে যায়।
directed that the designation of the respondent number 7 as appearing in the instant petition be corrected as Director.
As Director.
Director. Bureau of Investigation instead of Director General. CBI. History is directed to make necessary corrections in the cost title. After that, list the matter again.
Yes.
I'm appearing for
For admission, my lord.
All the respondents are represented.
Yes, now.
All respondents are represented. List the matter again on so and so for admission. Is 50.
Lordship, as per the last office note dated 23/12, the service on the respondent number 2 is not complete, Lordship.
Service on respondent
Will not
number
take
2
fresh step
not
into
yet
that,
complete
Lordship, and pray for a stay of the impugn order.
as prayed for by petitioner. Fresh steps may be taken.
Lordships, they have already initiated execution proceedings, Lordship, and today is the date for making payment, Lordship.
Can we grant a blanket stay?
Lordships. Lordship, without taking into consideration my affidavit on assets and liabilities, whereby I have stated that my monthly income comes to around 6,000 per month, Lordship, to rupees 6,000 per month. The learned court below on its own made a presumption that I am a skilled electrician and I earn an amount of rupees around 15,000 per month, Lordship. On its own, the court has presumed, without taking into consideration my affidavit. I'm a petty electrician, Lordship, and sometimes several days I have to go without work. And moreover, I deny the marriage with the respondent number 2, Lordship.
You are directed to pay 10,000.
4,000, Lordship, 4,000 per month.
Not an exorbitant amount.
Lordship, I hardly earn rupees 6,000, Lordship. Till then, some protection, till disposal of this case, some protection may be granted, Lordship.
If you admit it's 6,000, then you must be earning 10,000.
No, Lordship, several days I have to go without work also. I'm a petty electrician, Lordship. 15,000 is not that I earn, Lordship. Stated that on oath, Lordship, before the honorable court
We'll
below.
consider on the next date then. Okay, 21st.
Today it's
Based on
date for making
21st.
payment, Lordship. Some adverse order may be passed if I do not make the payment,
The
Lordship.
court must have risen by now.
Lordships. A short date may be fixed, Lordship.
Yeah, give a date.
21.
May it please your lordship. In this matter, in the IF 766, your lordship has directed that they be paid the insurance amount to the daughter, the respondent, and the amount was directed to be paid by 12/12/25. And then it was not paid. So before the trial court, we had made an application which was not paid. Now I have got an order that has been passed by the trial court, which says that DW has been issued on that behalf for most probably it's a distress warrant, so that the amount that has to be paid, that has not been paid. And the order, your lordship's order was on 2011 itself. Now it's more than 1.5 months. They have not yet paid the amount. And it was like it was a insurance amount which was deposited in the account of the respondent, and he has just to have to deposit it before the daughter. And your lordship on that order itself directed that I should provide with all the details of the accounts. We have already provided the details of the account on 21st itself, and thereafter till date it has not been. Now before I have a copy of the order, but this is not very clear. But DW has been issued as per my instructions that I had. We may approach the court on the next date.
So what is left for this court to do now?
Basically, this part already DW has been issued. So it was fixed for report on DW. So that was fixed on 20. Take a data. It was
22/1.
22. So that part, your lordship, court will take care. Anyway, your lordship has already given an order, and that was. Now, second part, your lordship, with regard to the other amounts and all. On the last occasion, learned friend was not there. He is here today. The amount that was to be paid as per the IA with regard to the monthly school fees and other things, that was also not paid for since 3 years. That has also accumulated to a high amount. That is to be decided subsequently. That part is also there. So two parts. So first part, your lordship has already given an order. Already that order has not been complied with. Lordship will only to that extent observe that it has not yet been complied with, and DW has been issued by the lower court, and the process will continue as per law. That is there, your lordship. If there nothing happens, then we can always come back before this honorable court.
Submit lordship. Lordship, I see, had submitted his submission, but his submission is wrong. As I am stating on oath lordship, because on the last day when the case was referred, was taken up in the lower court, in the Learned Family Court, the means the client of my learned senior was not appeared. She was absent. For the 2 consecutive days, it was mentioned in the family court, but she didn't appear. That is her personal. I don't want to comment on such things. But the thing is that the honorable the Learned Family Court had stayed the order. No DW distress warrant has been issued. The learned principal judge of the family court
has stated the order passed by whom?
lordship. No, family court had stated that they will wait till 21st of this month. After that, they will pass the necessary order. As stated.
No,
As stated verbally, lordship.
I
That the
have given a
principal
copy
judge,
of the order, your lordship, not verbal orders.
moreover, the order
This
which,
is a as
moreover,
per, I
the
think,
order
is
which
a-
your lordship had passed, against that, we have already filed the order which your lordship had filed on 2011-2025. We had filed an IA that is numbered as 1334 of 2025, which has been listed today.
That part I'll argue on that later. First thing is that this order which I have given is on 17/12, your lordship. It has specifically indicated that DW issued, and 22/1 is the next date for a report. But how can I say, oh, you're misleading, your lordship? Or not? This is, I have
Because-
just got this order.
Because I was present on that day. I was personally present on that day before the learned
you
principal judge family court lordship. That is why I have stated before your lordship.
I have given the order. You can verify it if possible. And second,
Whatever may have been observed by the family court, how does it take away what has been passed by this court on 2011-25?
Yes, lordship. Regarding that order which your lordship
12,
had
12,
passed.
your lordship has fixed. Now he has to answer why he has not paid on 12.
Lordship, regarding that lordship, we have.
What does the appearance or non-appearance of the
That is a different.
wife matter?
That is a different chapter.
It's not a different chapter. You were directed to deposit the money within a fixed period.
Lordship.
You have not.
Lordship, the thing is that on 2011-2025, your lordship had passed an
Now,
order.
if you want, we can call your client here and send him straight to jail.
No, lordship. The thing is that on 2011-2025, your lordship had passed an order where my client has been directed to pay the amount. Against that order, we have already approached Supreme Court, lordship. Against this order, lordship.
Where is that any
Your
order has
lordship,
been
that-
passed?
That we have already filed in 1334 of 2025, lordship.
They have not
We
filed
have
it.
stated.
They have stated, they have not given any documents, whether any filing number.
Where is your
whatever
filing
it
slip?
is.
Lordship.
No number can be
Then
sent.
lordship may fix the matter. Tomorrow I can bring the filing slip, lordship.
And there is no stay order from the Honorable Supreme Court also. Whether,
My learned friend is also aware, my learned
No, no,
senior,
I'm
that
not
once the
saying-
case is filed, it will not reach automatically.
no, you
It
have a
takes
filing
time.
number.
It takes time in Supreme Court, lordship.
Whatever-
Yes, filing number is there, lordship. I can provide it. Let the matter come up tomorrow. I will provide the filing number.
Filing doesn't mean that any stay is there automatically.
Until and unless there is stay order, your lordship will,
That's
your
why we
lordship's
have prayed,
order
that's
will
why
remain.
we have prayed in IR3 1334 for 4 weeks time. So that in the meantime, let the matter be heard in Supreme Court and
What IA 334?
1334 of 2025, I8, lordship.
Ending here.
Yes, lordship.
They
No,
have
no,
also filed
we
an
have
IA here
filed
for
one
extension of the time.
for time extension, lordship. 1334 of 2025.
1334. For an- Nowadays, this is a click of a
Regarding the
click
insurance
of a
policy,
finger, the numbers can be, the filing number, whatever it is, can be obtained, your lordship, even from this court, any court. Only they have stated that
regarding
they are
the
filing
insurance
a,
policy,
that cannot give
which
a
my
leeway.
learned
your
friend had submitted before your honor, and accordingly your lordship had passed an order. In that policy, my client was the policy holder, and the daughter is only the nominee. That is clearly written, lordship, as per section 39 of the Insurance Act, lordship.
Now
And
they cannot raise all these things, your lordship. The court has, division bench itself has
division
given an
bench
order.
stated that policy, insurance policy premium has to be paid. In division bench has not stated that the total premium, that means the final amount has to be deposited in the daughter's account, lordship.
Yes, has to be.
That is a presumption, lordship.
Court has said if they do not pay, an amount of 9 lakhs should be deposited in the name of the daughter in any nationalized bank at Guwahati. There's a direction, specific direction.
Direction is that they have to pay the insurance premium, lordship.
Now these things,
Now
your
the
lordship,
division bench has not stated
so
that
that the court
the
has,
final premium has to be paid into the daughter's account, lordship. That is not been reflected in the division bench order, lordship. Now it's a matter of strange how my learned senior has come to a conclusion that the final premium has to be deposited into daughter's account, lordship.
they have in fact stated in the honorable division, before the honorable division bench, that the policy is in the name of the minor daughter. Now he says it is in his name.
Lordship, this is the copy of the policy.
Whatever it is, I am
I
before
have the copy of the policy, lordship.
If that is in the name of the daughter and they don't pay, that is the reason
Daughter
court
is
has
the
directed.
nominee, lordship.
Then why they have not pointed it out before the court that she is a nominee, we are not going to pay it. Only just the premium will pay.
These
if we
were
did.
points which were supposed to be raised by you on the previous date when this order were passed, but you remained absent.
Lordship, on that day I was absent, lordship.
Yes.
That was an
So
inadvertent.
that is your professional negligence.
That was an inadvertent.
So we
mistake
cannot,
on
we
my
cannot
part.
tolerate this order
That is why, lordship.
for your negligence.
Lordship.
Until there is a stay order by the Honorable Supreme Court, your lordship order prevails. Nothing else can be done, your lordship, at this stage. Let the Supreme Court decide if they have already approved.
Anyway, what order is required to be passed today?
Lordship, I am paying for 4 weeks time in I 1334. That may kindly.
Let them provide with the whatever filing and all, then let them provide it to us. We'll also then appear there if required. Since we'll also be a party there, obviously.
Yes. Heard learned counsel for the petitioner as well as learned counsel for the respondent. Is submitted by learned counsel for the petitioner that respect of order dated 2011-2025 passed by this court. There has not been any compliance by the respondent, and the learned family court has already distress warrant, a photocopy of which has been submitted. Hence, list the matter again.
After the due vacations, your lordship, let it be listed.
22nd, 23rd.
22nd or 20th.
IA 1334. This IA has been preferred, seeking extension of time for compliance with the dated
2011.
20. No, I got to edit. 2011-25. As the applicant stroke respondent has deferred and appeal against the state order before the Supreme Court. petitioner to furnish particulars of the said application. The next date fixed. List again on same date.
Obliged.